Hi, we're here for week 5. I'm happy that y'all are ready to listen to this. We're going to be talking about 2 laws that require accommodation, the ADA as well as the Title VII with respect to religious accommodation. In addition, we are going to be talking about the Family Medical Leave Act and what is required under it. So we will get started, but before we go to the next slide, remember that this lecture is not a supplement to the reading and other assignments, or it is a supplement to the reading and other assignments, but it does not replace those, and so you need to follow those other materials to ensure that you cover the proper information that will be required to do the other assignments and testing requirements of the class. There are the federal laws that we're going to talk about today, and why they're grouped together in this presentation are the ADA as well as Title VII. And the ADA is what is the Americans with Disabilities Act, and it requires that the employers accommodate qualified individuals with disabilities who can perform the essential functions of the job. And that requires an affirmative accommodation and the employers to take steps to allow them to be employed. And they cannot just say, look, we're not going to change something associated with this job or provide an extra benefit because we're not providing it to other people. You do have to require it as a part of a reasonable accommodation under the ADA. Also, with respect to religious accommodation, you also have to accommodate religious beliefs under Title VII. So religious discrimination doesn't fall under its own separate statute, like the ADA is for disability. The ADEA, Age Discrimination and Employment Act, is for people over 40. There is not a particular one like the Religious Discrimination Act. That doesn't exist. It falls under Title VII, which says you won't discriminate based on someone based on their color, national origin, gender, etc. And one of those is religion. And that's where you would find the protections for religious discrimination. You're required to, it's harder to get an accommodation because you have to show under disability that you're entitled to it and that you're truly disabled. And if you can show that, then you're entitled to accommodation. And the accommodations under the Disability Act, the ADA, are a lot more burdensome on the employer than under the Title VII with respect to religion. Religion, there is less need to accommodate the religious beliefs, but that need has increased over the years. There was a Supreme Court case in 2023 that has expanded on the requirements for employers to accommodate religious beliefs, and how that's going to be interpreted by other courts and how much employers are going to have to do will be determined. But it is not as substantial. It doesn't require the substantial burden and hardship it would under the ADA. Because if there's a substantial burden and undue hardship under the ADA, you do not have to provide the accommodation. And under religious accommodation, under Title VII, that burden is a lot less. And so you can have a less substantial burden, and if that's the case, you could not accommodate the religious belief. There's also a statute under the Title VII also requires some accommodation for pregnancy, and if you're going to provide certain leaves to other people, then you have to also provide those affirmative accommodations to people who are pregnant. And so there is some affirmative duty to accommodate there as well. Under the other statutes, other protected classes under Title VII or the Age Discrimination Employment Act, there is no affirmative duty to accommodate their protected class status. So the only protected class statuses that require some affirmative efforts on behalf of the employer is the ADA for disability, Title VII for religion, and also Title VII and the Pregnancy Worker Protection Act also requires that as well for pregnant people who are pregnant. Okay, now turning to disability under the ADA, I said that you only have to accommodate people who have an actual disability or record of disability. And so to seek that accommodation, the employee first has to establish that they have a current disability or have a record of a past disability. And so we need to talk about a little bit what is a disability under the ADA. And there's 3 ways to establish a disability that would require some kind of protection under the ADA. And the first is a physical or mental impairment that substantially limits one or more major life activities. And so what they're talking about is a long-term physical condition, not like a flu or a pink eye or something that is even a broken bone that isn't expected to last long-term would not be what because of its temporary nature, would not be what they're talking about under disability. But it can be physical disability, if you have some kind of cancer or something like that, or needing to go to radiation treatments, but it's also mental disability or mental impairment, and that substantially limits one or more major life activities. And what are those? Those are pretty broad. Historically, they were very narrow, and very few people were found to be disabled. And they amended the ADA, and around 2008 or 2010, and when they did, there have been a lot more people found to be disabled since that time. And in those amendments, what I have told employers and what you should think of is most people will be able to satisfy the disability component, because a major life activity is eating, drinking, thinking, and concentration. And so it's so easy to prove a disability now and have a doctor do that. You should focus more on the accommodation. I don't know, on the slide before, there was a reference there to the hotbed of litigation associated with not providing appropriate accommodations to people who have disability. And so when they redid this definition under number 1 here on this slide, they really basically, most people who have some kind of mental or physical impairment, it will hit this next standard that substantially limits one or more major life activities, and thus they will probably be found to be disabled, and that the company should spend its time focusing on how do we accommodate it, and is it going to be a substantial burden and undue hardship on the company to do so. And if it is, then you do not have to accommodate that disability. Another way to become disabled under the statute, or to be qualified as disabled under the statute, is a record of such impairment. And that would be somebody, let's say, who is a former alcoholic. That could be considered a disability, alcoholism, or someone who had a former drug addiction, substance abuse addiction. And if you have something like that, you could have a record of impairment, or maybe you had cancer but have been cured. And so what kind of accommodations would those people that I just described need? They would have a record of such impairment, and their accommodations would be possibly to go see and attend AA meetings or Narcotics Anonymous meetings, or go back for a follow-up treatment for cancer. So you would need to see if they're still cancer-free. And those would be accommodations that could be had. It would be reasonable for people to take off time to go attend those kind of meetings, etc., or appointments. And then the last way to be disabled is being regarded as such an impairment. Well, under number 3, you're not really disabled because someone thinks you are, but you're not. And so there's no accommodation needed under number 3. But you need to be careful with what people are saying in the workplace. And what we have seen is people get loose and say, I think they're bipolar, or I think they're depressed. Well, those kind of comments, and if people continue to say them in emails or texts to describe when someone's having a bad day, will treat someone or you're regarding them as disabled even when they aren't. And then they may have some protection or would have some protection under the ADA. It wouldn't be a protection that would require accommodation because they are not needing accommodation because they don't really have a disability. You're just regarding them as a disability. And so if 1 and 2 happens and they have this disability, what companies have to do is this last bullet point, which is engage in the interactive process. And you're engaging in the interactive process with the employee to see what accommodations they need and can you provide those accommodations. And that interactive process should be documented with emails and follow-ups so that you can properly show if they come in later and say you didn't accommodate them or you didn't work with them to do it, that you have that interactive process documented. Moving on to Title VII, religious discrimination. And before, I don't want to go back and do the last slide, but I want to add one more thing to that last slide. With respect to that, who's able to seek accommodation or prove a disability under the ADA? It's both employees as well as applicants. So if your application process requires certain things and people say, well, I need some kind of accommodation with respect to the application process, then you have to give that accommodation to both an applicant as well as an employee. Okay, going back to this slide on religious accommodation. Again, this is going to fall under Title VII. Title VII defines religion differently than what you would typically think. Most of us think of religions as religions that we're familiar with, such as, Catholics or Baptists or Methodists or Muslims or Hindu, or those types of religion that are kind of well recognized. But the way EEOC and Title VII defines it is all aspects of religious observance and practice as well as belief. And the thing with religion is, and it doesn't have to be a religion that we recognize or believe. It's something that they believe or recognize that's held with a strong conviction that would be equally held with someone that has a more traditional religious belief. It's not something that someone is, it's what they practice and express through their words and deeds. So it's the behavioral aspect of religion that requires accommodation. Just because someone, is a Catholic or is a Muslim or something like that, you don't necessarily have to accommodate it. But if they want to practice the religion or do certain behaviors associated with the religion, that is what may require some accommodation. As I talked about in the previous slide, the EEOC treats religion or religious beliefs and they define it as moral and ethical beliefs as to what is right and wrong, which are sincerely held with the strength of religious views. And so it doesn't have to be a belief in any particular God or deity, and it is not required. And so atheism, being an agnostic, there is cases that say church of body modification can be a religion. People who worship the devil could be a religion. So there is a lot of different things that will be covered by Title VII that are not the typical religious beliefs that one would think of. But it has to be sincerely held. If they haven't told you about it and it only comes up once they've been in trouble for some kind of discipline, and they say, well, I was exercising the religious belief, you can still discipline for them for the first time. But if they need to engage in that activity again and it's found to be a sincerely held practice, belief, and a practice associated with that religion, then you may have to accommodate it in the future. And so you just need to be aware of that. Also, make sure that you don't allow certain meetings, like if they allow Bible study at the workplace on Tuesday mornings or during a lunch, and if someone comes in and says, look, I'd like to have a devil worshiping Bible study or some other Bible study, or I guess it wouldn't be Bible, but some kind of study of some type of sincerely held organization that the EEOC would found constitutes a kind of religious belief. And if you didn't allow that, but allowed the Christians to have their Bible study, but not the agnostics or the atheists to have their Bible study or their study, or the devil worshippers, then you would be discriminating based on religion by allowing the Christians to have one, but in a meeting space at the workplace, but not the others. So keep that in mind, along with the religious belief accommodation aspect that employers are required to do. The last slide of this presentation today deals with the Family Medical Leave Act. This is a benefit that is required and is associated with allowing people to take certain leaves when they have some kind of serious health condition. And so it is oftentimes comes up when you're dealing with the Americans with Disabilities Act and looking at accommodations, because some of the accommodations that is considered to be a reasonable accommodation of the ADA is providing someone time off to deal with their disability or condition. And so there's a lot of overlap with the family medical leave and the ADA, so I thought it was appropriate to cover it here, where it could also be covered in the benefit section of the text and lectures. But the Family Medical Leave Act, so if you have a serious health condition of the employee, and that typically is a condition that would require 2 or more or 3 or more treatments at a hospital or by doctors over a course of time, or overnight stays at the hospital, can be considered a serious health condition. And so this provides employees up to 12 weeks of leave for a serious health condition of themselves or certain family members, and to care for them. It also provides up to 12 weeks of leave for the birth of a child, or to care for a newborn, or placement of a child from adoption or foster care. And that leave for the childbirth you have to take within 1 year of the child being born. And it has to conclude within the 1 year of the child being born. So if you were going to take your 12 weeks, you would need to start no later than the 9th month after the child would be born. Now, most of the people who are going to take this at the initial outset are going to be women, because if they have the baby, they will typically take their leave associated with the childbirth. But a male dad could wait, or a partner of someone could wait and take the leave later. Now, and if someone has a adoption, those time periods could also be, but any time during over that year, they can take that 12 weeks up to leave. Now, not every employee is entitled to family medical leave. To be entitled to it, there's an additional requirement that you have to have, the employer has to have at least 50 employees within a 75-mile radius. And if the employer has more than 50 employees within a 75-mile radius, then they have to provide family medical leave to employees that are within that radius. And then another requirement on the employee to be eligible for it is they have to have worked been employed at least 1 year with the employer, and within the last 12 months, they will have to have worked at least 1,250 hours for the employer. And if they satisfy those requirements, then they're eligible for the leave, and then they can take the leave if one of these 3 things or 4 things happens on the slides, which is the leave for a birth of a child, leave for their own serious health condition, or to care for a family member with a serious health condition. And a family member on this third bullet point is a child, a parent, or it can be another person who you stand within, like a typical parent-child relationship, even though they may not be your child. Like if an aunt is caring for a niece or nephew as if it's their child, and they live with them and treat them basically as if a mom or dad would be treating them, that also can be someone who could take leave with respect to that minor. But it does not include leaves to go take care of a grandparent or something like that. Now, companies could provide that if they wanted to, but it wouldn't it wouldn't qualify as family medical leave to go for a grandparent or an in-law. It has to be your parent, your child. That's the kind of familiar relationship that they're talking about here. If you're taking leave associated with military leave, like if someone is hurt in the military or injured associated with the military, then they get up to 26 weeks of leave with respect to that. So they get a longer time, to care for someone who's injured and has a qualifying exigency with respect to military leave. The family medical leave also requires an extensive policy and notice to be given to the employees about it. And there's a back and forth that they have to say. They also have to provide you, if an employee is going to go out, if it's a known leave, like a pregnancy or birth of a child, they have to give you 30 days notice. And if they don't do that, then you could deny them the leave until that 30-day notice period is done. For an elective surgery, they also have to give that kind of notice. But for an emergency surgery or something like that, or an emergency sickness like a heart attack, they can then start taking the leave immediately at that time when it happens, because you can't anticipate those and you can provide notice at that time. But the policy and procedure with respect to this should be in the handbook, and we talked about handbooks in week 3, and this would be one of those types of policies that would be in a handbook. So to sum up this lecture, employers have to give accommodation and take affirmative steps with respect to employees when they need it to do the essential functions of their job under the ADA and with religious accommodations. One thing I forgot to mention is under the ADA, if they cannot perform the essential functions of their job with or without accommodation, then they may be so disabled that they're no longer qualified under the statute. And if you can't work at all, and then there's really no way to accommodate it by some leave. I mean, you don't have to give indefinite unknown leave, or you don't have to take away essential functions of the job, because if you do that, then that's considered to be a substantial burden and undue hardship on the employer, because now they can't perform the job at all. And if they can't perform the job at all, even with reasonable accommodations, then they're so disabled that they're not even qualified. And then you also have to do accommodations for the religious beliefs, and the key thing there is don't think of religion as what you would typically think of religion. It's much broader than that. And finally, the family medical leave, you have to see, is the employer required to give it? Do they have 50 or more employees within a 75-mile radius? 2, does the employee qualify? Have they worked for the company for at least a year? It doesn't have to be consecutive, but they have to have worked for them for at least a year. And within the last 12 months, has the employee worked over 1,250 hours? And if so, then when one of those conditions happens that are on this slide, you have to provide them that leave. It's an unpaid leave. You can pay them, and you can also make them exhaust their vacation and other PTO while they're out on that leave. But if you're going to do that, that needs to be in the policy and told to them on the front end so they'll know that. So that ends this lecture for week 5.